This conference will now be recorded.
Good. You're in
Okay.
Bermuda still, or you?
I just flew back to Bermuda today. I was in. I'm just putting a. 1 second.
Right. Okay. So my name is Robert Platt. I'm secretary of the Alumni IFC, and joining us tonight, among other illustrious guests, are Zach Greenberg, who's a project manager with the Foundation for Individual Rights and Expression, FIRE, and Clark Brown, who's general counsel of the North American Interfraternity Conference, also known as NIC. And we're going to discuss fraternities and the First Amendment. And I'm first going to give you a very brief overview, and then we'll walk through scenarios with our two experts and see what their reactions are. And then, you can always leave questions in the chat, and we'll try to cover all interesting points. So the first question is, what is the First Amendment? And of course, as Congress shall make no law respecting the establishment of religion, the prohibiting free exercise thereof, abridging freedom of speech or of the press, or the right of people to peaceably assemble and to petition the government for redress of grievances. And the Supreme Court has generally broken down sort of the idea of this into expressive rights and so-called intimate association rights. So your right to stand on the balcony of your fraternity house wailing away at the evils of the world is an expressive right, and your right to sort of get together with other people in the chapter room and meet and greet each other is called so-called intimate association rights, and both are protected by the First Amendment of the Constitution. And of course, in addition to the federal constitutions, many states also have First Amendment-like provisions. So what about Cornell? Is Cornell subject to the First Amendment? I may disagree with other people on this call because this is very debatable. In the case of Holden versus Cornell, it was held that Cornell is subject to the New York State Open Meetings Law when meeting about statutory colleges. So, for example, when the Cornell Board of Trustees get together and the part of the meeting where they talk about the 4 state schools, they have to meet in open. Whereas if it's the endowed colleges, they don't. We've never really litigated the point because Cornell generally has been too embarrassed to give statutory college students more rights and then withhold those rights from the endowed students. So generally, Cornell has tried to draft its policies in a First Amendment friendly way. And then a lot of what Cornell has been doing has been covered by Title IX policies. And of course, Title IX is state action, so it has to, when Congress enacts Title IX or the federal government enforces Title IX, they've got to do that in a First Amendment friendly way. So the big Supreme Court case on Title IX versus free expression is Davis versus the Monroe County Board of Education. And it draws a line between creating an impermissible hostile environment on the one hand and protected speech on the other. And this Davis test is expressly incorporated into the current Title IX final rule that is in effect. And there are 3 parts to the test, and all 3 must be met. The conduct must be severe, pervasive, and objectively offensive so as to deprive the student of his or her educational opportunities. All 3 must be met. If you were a private employer like McDonald's trying to regulate the speech or conduct of your employees, there would be an or there. But in the case of this, recognizing the educational environment and protected speech, you have to meet all 3 tests to be covered by the Davis versus Monroe County test. So what about Cornell? If, assuming I didn't convince you that Cornell was subject to the First Amendment, you could argue sort of that Cornell promised you rights, sort of like a contract, and Cornell has published core values, including we value free and open inquiry and expression, tenets that underline academic freedom, and so they really promise you free expression. In addition, the faculty has adopted a policy on academic freedom and freedom of expression that Cornell also has to honor. So with that background, and assuming for a moment that Cornell was subject to the First Amendment, or that we were all attending some other university that was so public as to be subject to the First Amendment, let's examine some scenarios with our two experts. And the first scenario is members of a fraternity joke about conducting a pig roast contest to see who can have sex with the most women. As a tiebreaker, the person who has relations with the heaviest woman wins. This contest never actually happens, but an account of it somehow gets reported to the Title IX office. So, Zach, protected by the First Amendment or not?
Yeah, thanks for the introduction, for providing the scenario. This is definitely protected by the First Amendment, which of course protects offensive expression, jokes, and other forms of speech. This case is very similar to a Fourth Circuit case that came out a while ago, the Oda Chai at George Mason University, I believe, where the frat conducted an ugly woman contest filled with sexual and racial stereotypes, and they were punished by the university, and the court said very definitively that merely offensive speech, offensive expression, cannot form the basis of university punishment. And here, Title IX, even the Department of Education has made clear that merely offensive, subjectively offensive speech cannot form Title IX. It has to be something more, a course of severe and pervasive conduct, not just expression, that undermines a victim's education. So the answer to this would be picked by the First Amendment. And of course, of fire, we always encourage people to react to offensive speech with their own speech, with more speech, instead of violence or censorship.
How about you, Clark? What's your judgment on this one?
Well, thanks for having me. And you'll probably hear a lot of this tonight, but largely I agree with Zach. I think it's important to start and just recognize that this is truly offensive, a despicable thing to even joke about. If we're not instilling those sort of values in fraternity men, then we're probably doing it wrong. But I agree with his assessment on the First Amendment. I will say I think I probably come down that that if this case is fully adjudicated by Title IX, of course, I mean we're working off of a hypothetical, so we'll take it for what it is. I wouldn't be so quick to dismiss that that there's an actionable issue of hostile environment here. I think we would certainly have to know more, um, and just how serious was the joking, and just the facts and circumstances that surround that. I will tell you that just practically, this sort of thing is what underlies many across the country Title IX adjudications for a hostile environment, sexual harassment. So there could be some Title IX consequences here. I think it's probably a close call, even if the underlying speech is protected by the First Amendment, which I agree that it is.
Well, Clark, could I ask you whether it made a difference to you if none of the fraternity members had ever talked to any woman whatsoever about this joke? That it only leaked out to the Title IX office later, but it wasn't direct communication by the. In other words, there was no one specifically being harassed.
Mm-hmm. Mm-hmm. Yeah, it makes a difference. It's something that you would put into the factor, into the equation of all the factors that you would consider. I think it probably makes a finding of wrongdoing under Title IX less likely, but I still wouldn't rule it out, because hostile environments can exist, sort of, on their own. So I'm not sure. I don't necessarily know that I would see discipline in that scenario that you lay out. But I wouldn't trust that to be the outcome at every university. Let's put it like that.
Well, as a matter of fact, there was a Title IX proceeding on these facts at Cornell, and they were found guilty of violating Title IX.
I'm not surprised at all. I mean, that would have been my assumption.
Right. Let's move on to the next scenario. Rush regulation. What are the limits on how much fraternities can recruit freshmen? At Cornell, we delay formal rush until the second semester of freshman year. Does the right of association, freedom of association, allow Cornell to regulate how much individual fraternity men can contact and make friends with, befriend prospective members? Clark, why don't you go first?
Yeah, well, this is a great one to have NIC and fire on, because this is one of the key issues that we work on together often. I think this is permissible. It's not. It violates our positions. We argue against it. We advocate against it. If it's not something that, if it's something that is forced on the community by the administration, of course, we never want to see. We want to see recruitment happen year round. I will say, when it comes to deferred recruitment, um, it's largely been, and Zach can probably speak to this more from a practitioner standpoint, but it's not been tested very many times in courts. And the times that it has have, most recently, University of Southern California, where there was some extensive multi-year litigation about deferred recruitment, and it wasn't successful. So yeah, we want to be really careful about thinking that we have a viable cause of action when it comes to deferred recruitment, because you're going to get into a balancing test with the school, and the school is going to come back with all these reasons about why it's smart to defer recruitment, and put forward kind of academic or other reasons that they want to implement a deferred recruitment policy. And some of those could put fraternities in a very tough position to argue against. So I'm not particularly bullish on pursuing deferred recruitment in litigation.
Well, the problem at Cornell is that they had first enacted a freshman residency requirement that, for educational reasons, all freshmen must sign year-long 2-semester contracts to live in the dorms. There are a few exceptions if your family has their home like within 25 miles of campus, but everybody else is required to live on campus. And then, effective this September, they extended it for a second year. So now you
Very
have to
common. Yeah.
live on campus for 2 years, but they've sort of deputized the off-campus fraternity, Greek life houses, and co-ops to count as being on campus for that purpose. What about you, Zach? How do you feel about deferred rush? I know you've litigated some cases on this lately.
Yeah, Clark is exactly right. It's really difficult to litigate these cases. Clark actually has litigated these cases, but we advocated for universities to rescind the policies they have regarding deferred recruitment. Our conception of it, and of course, we're an advocacy group, we try to extend the law as much as we can to protect students' First Amendment rights. Our conception is that this is a violation of students' right to associate and the group's right to associate. So student groups have the right to determine their own membership. They can recruit individuals regardless of their race, their creed, their ethnicity, including their status at the school. That's protected under the First Amendment. Students also have the right to join the groups of their choosing. They can join fraternities, not join fraternities. That's their right under the First Amendment. And deferred recruitment seems to be a violation of that right, because it's telling a group of students, only a very certain group of students, that cannot associate with a certain specific group of groups. And so that is problematic under the First Amendment. The issue is that it's not necessarily expressive. There's no real speech nexus here. And the right to associate with social groups is not very clearly established. So it would be difficult to litigate. Hasn't really been tried at a public university where the rule was clearly stated. And so we'd be curious to see if there are students out there wanting to file these lawsuits, and if there would be, FIRE would be happy to get involved.
Okay. Our next scenario is, suppose you have a university and it imposes two different requirements on its Greek houses. The first is that each chapter must belong to a national, not be a local fraternity. And the second that requires all recognized fraternities must be members of the IFC. That some chapter that belongs to a national that doesn't require IFC membership, the university would require it anyway. So the question is the freedom to have fraternities that don't belong to nationals, and the freedom to not be part of the IFC. And the question is, how does the First Amendment right of association affect either of those dimensions? So how about you take this one, Zach, first?
Sure, happy to. When universities bestow recognition upon student groups like fraternities, they can kind of set the terms of their relationship with the groups. They can require the groups to, for example, have a certain GPA or be all university students to comply with other policies. And one of the most frequent requirements is for the groups to belong to a national chapter, a national organization, an affiliate that they can associate with the group and kind of use to ensure the group is compliant with university policies. This seems to be a pretty well-established restriction. We think that it's probably fine so long as it's not used in a discriminatory manner or used to single out certain groups for special treatment. As long as it's applied across the board equally to all organizations that are Greek life, then we think it's probably okay under an associational perspective.
And isn't one factor really insurance? That is to say that most fraternities get their insurance through their national organization, and therefore the university has an interest in making sure the chapter is well insured, so they would use that as a rationale.
Yeah, there's a lot of benefits of fraternities to be associated with a national chapter. Not even just insurance, but just advice, about helping recruitment, financial stuff like that. I'm sure Clark can talk more about that relationship as well and how the university interacts with the national chapter as well as the local chapters. But in terms of a restriction, it's pretty much fine under the First Amendment.
Right. Okay, Clark, it's your turn to hit the home run here.
Yeah, I don't think that I don't have any. This really breaks down into whether the groups are recognized by the university or they're not. If they're recognized by the university, these are going to be permissible regulations. If they're unrecognized by the university, um, I think there could be some, a potentially viable First Amendment challenge on the first half, whether they belong to a national, because at that point you're saying here's an unrecognized group of students who are joining together socially, and you know we're saying that they have to be part of a national organization, yet they're not getting any they're not under any sort of recognition agreement from us. So that group of students could potentially, I mean, it would depend on how that group is formed, what their purposes are, what their size is, what kind of activities they're engaged in, how they meet, where they meet, all of these sorts of things. So in the unrecognized scenario, and then I don't think in the unrecognized scenario that they would want to be a part of an IFC, nor would the university want them to be a part. So I'm not sure it really matters.
Right.
IFCs fall under the purview of the NIC, so this definitely hits close to home. All of our member national fraternities require their local chapters anyway to be a part of an operating IFC that has bylaws and meets regularly and does any number of requirements. So yeah, I mean, but if we're talking about in the recognized scenario, I would definitely agree that these are probably permissible things for the university to require. It's hard to see how a student would have a viable First Amendment case, or a group of students would have a viable First Amendment case here. Not to be a party pooper, but
No,
I don't see it.
I agree with you. I think the main argument is that fraternities and the fraternity movement is to teach self-governance, right? And that would, and if you believe that an IFC is the embodiment of self-governance of the collective group of fraternities, then there's a very clearly articulable educational rationale for such a requirement that it would be very hard for a court to really look behind. Okay, let's try the next scenario. This is one that we really spent a lot of time on here at Cornell. Assume that this university has a clear and convincing evidence standard for convicting someone, an individual accused of violating the university's conduct standards. But they say the preponderance of evidence standard should be used in adjudicating the collective guilt of a organization, including a fraternity. So if the track team is accused of violating the campus code of conduct or something, it would be the preponderance of the evidence standard. If a fraternity is, it would be preponderance of the evidence standard. And I find this sort of debate fascinating right now because in the headline news every day, it's the Trump organization being on trial, right? And so finally, I think a lot of people, a lot of men on the streets or men in the chapter houses have finally grasped the idea of an organization's accountability under a standard of conduct or a criminal code. And this is sort of what Cornell has done. A lot of people think that's unfair. Where do you experts come out? Clark, why don't you go first?
Gosh, this is a great intro. I don't know. This is not something that I've spent a whole lot of time considering. I don't like the fact that there are two different burdens of proof, and I'll tell you why. Because I have a concern that those could be applied effectively by the adjudicatory body of any campus. I mean, that's, and how to know the difference between, one second. My dog was barking. That's what happens when you work from home. I would have concerns about any campus adjudicatory body being able to sort of flip back and forth between different burdens of proof. Okay, today I'm doing preponderance, tomorrow I'm doing clear and convincing, and even if they can, I still would like to see them be uniform across the board. I do wonder, if it is. So you say it's all organizations, so the track team would be under the preponderance. Is that right?
Yes.
Mm-hmm, mm-hmm. So okay, so you want to make sure of things like that because if it's just fraternities or just sororities, then you could potentially have some sort of disparate treatment issues that arise and potentially even causes of action under Title IX for gender stereotyping, but doesn't sound like that's really an issue. So I think where I come down is I would like to see them be uniform across the board one way or the other. That would help with more effective adjudications.
And excuse me, Clark, I think the other relevant factor in this one is that in this student code, there's no definition of when is a violation something that's committed by one or two or three individuals, and when, if those individuals happen to belong to the same organization or sports team, is it a violation of the whole team or fraternity? So you not only have two standards, but then you have the complete absence of a definition of when one standard applies and when the other applies.
Yeah, that's a great point. And whether if Clark and Zach are members of one fraternity, and we do something that violates the student code, to then adjudicate the whole organization seems unfair on its face. I mean, potentially if we were the president and vice president and and we were doing something in the scope of our duties. But I do think that where a lot of schools, not all, but a lot of schools struggle is what exactly defines organizational conduct. And so one of the things that the NIC has done is during the last comment period for Title IX regulations, when the Biden administration issued the notice of proposed rulemaking, we have met with and been advocating with the U.S. Department of Education for years now that they really need to provide in the Title IX commentary organizational due process protections and more explanation around the issues that you just raised, and that really speak to what is organizational conduct, and if so, what are the protections that are going to be in place. I think this is just a really gray area. I think that you often see individual conduct be adjudicated as organizational conduct. And you probably sometimes see individual adjudications in instances where it could arguably be organizational conduct. So I think the whole area is really ripe for clarification.
Okay. Zach, do you want to weigh in?
Yeah, sure. So we always advocate for due process protection for students and student groups, especially fraternities. When it comes to the standard of proof, I think the clear and convincing evidence is much more protective of due process than merely preponderance of the evidence, especially when applied to different standards. I think in Title IX, at the very least, requires the adjudicatory standard to be uniform throughout all different student groups, and professors, and students themselves. Um, the only issue I see with this case is if there are different standards for different types of groups. For example, if it's only on fraternities, not in like the swim team, or it's only on male students, not on female students, that could be an issue of differential treatment under Title IX, and that could be an issue. But I think a different standard for just groups as opposed to individuals are probably okay, although we would advocate against it. We'd advocate, like Clark said, for a more uniform standard, specifically the clear and convincing evidence standard.
Well, the rationale, believe it or not, given when this was drafted, was that organizations can just come and go, and that there's being suspended as an organization has less of a consequence than being suspended as an individual student. And of course, the irony behind that is that with the case of fraternities, we've got millions of dollars of real estate assets and a lot of net worth invested in these organizations, and you would think that those property interests, as well as due process interests and so on, would warrant them being protected as much as an individual Cornell student. I mean, I think suspending or expelling a Cornell student is a very serious thing, and you want to make sure there are no mistakes or no false convictions. And I would hope that people would realize that suspending or expelling a organization could have as grave a consequence or even more serious consequences. So the argument doesn't make any sense to me that the standard of evidence should be lower for suspending or expelling an organization. And in
Robert,
yeah,
sorry.
Go ahead.
No, if I may, I was just going to say I agree, and if that is an rationale put forward by the administration, that seems to be very short-sighted and sort of have, just a deliberately narrow view of the issues. Because if you say, well, organizations can come and go, but it's a huge deal to expel a student, that doesn't seem to take into account the fact that that organization that you're expelling has hundreds, maybe thousands of alumni who are probably engaged with the university more than the average alumnus is. So that's sort of a baffling rationale from the university, frankly.
Right. And in terms of due process, I do want to drop a footnote that the only university in the entire nation that got an A rating from FIRE on its most recent due process ratings was Cornell. We got the only A in the entire nation, but that wasn't for our Title IX regulations. That was just for our campus code of conduct regulations. Let's move on to scenario number 5, which is you have a on-campus judicial system, and it is amended to assert jurisdiction over all fraternities, both the on-campus fraternity houses and the off-campus fraternity houses too, and the reason being that they want to treat all fraternities equally. So for the purposes of what is, quote, on campus, the definition includes all the off-campus fraternity houses. And that does not apply to the boarding house where the track team happens to live, or the boarding house where the Sun editors happen to live. It's just fraternity houses. So, Zach, what do you think of that?
Jurisdictional questions are pretty tricky. Generally, universities extend jurisdiction over every student everywhere they're at, whether they're studying abroad, whether they're at home at vacation, whether they're on campus. The new Title IX regulations limit that a little bit. They cap in jurisdiction to only where the university has potential control over the environment, just it's the class or a program, not just a student as a student. So here, a judicial system sending to all campus fraternities, that could be problematic because if the fraternity is nowhere near Cornell or Ithaca, for example, if it's somewhere, say in New York, maybe it's in New York City, maybe it's not even the same state, but Cornell students belong there, to what extent can the university regulate the group's conduct? And I would argue that if the group is not within Cornell's orbit, if they're not either made up of university students or within Cornell's geographical boundaries, then the university has no jurisdiction over the group. But it's tricky. If Cornell tried to like punish the Ithaca, choir or chess club, that obviously be an issue. But it depends really on how far jurisdiction extends, and there hasn't been that much law about this. Universities tend to extend jurisdiction everywhere, but I would argue for a more limited approach to this.
Okay, Clark, how about this? And weren't there some cases like in I think it was Kansas or Nebraska where there were a lot of riots right outside fraternity houses that were just off campus about a year ago?
Yeah, so let me come back to that last point at the end. So let's a couple things here. One, I think if these fraternities in scenario 5 are recognized, I don't think there's an issue. And I think that that's really, if they're recognized by the university, I don't think there's an issue. That's point one. Point two is that Title IX in the scenario of arguably students, but definitely recognized fraternities, is going to extend jurisdiction to, in its adjudicatory purview would extend to this scenario under both the Trump rules and the proposed Biden rules. Zach can correct me if I'm wrong, but I'm pretty sure it's both. And so I don't see any issues. I mean, if you get into unrecognized groups, I think, I can't say for sure. I have to agree. I would have to defer really to Zach and, his sort of expertise as a practitioner that this is a complicated analysis. Robert, you raised a point.
Right, where there was a fraternity house and it had somehow been implicated by rumor in a sexual assault that occurred a whole year earlier. And then all of a sudden, all these rioters came, surrounded the fraternity house, forced the students to vacate the house, and spray painted rapists all over the building and so on, which was really conducting a riot, each of which was supposed to be a violation of the code if it was occurring on campus. But suddenly this off-campus fraternity house, what was the responsibility of the university to adjudicate those rioters?
Well, it's interesting, if the university is gonna extend its jurisdiction to adjudicate, say, harassment within a fraternity house at a fraternity party, you would want to see, them, when the fraternity members are victims of some other sort of conduct, that they be, that they receive the same protections that alleged victims did in the former scenario. So, that, again, it's about applying these sort of things equally, no matter the facts and circumstances. It's hard to imagine that a university would. Well, I don't know that it's hard to imagine, actually. Let me walk that back. Um, uh, it's unfortunate that a university would allow its students to vandalize, engage in criminal conduct against the residents of other students and turn a blind eye if that's in fact what they did. I mean, that would be very disappointing. And if I were advising a house corporation in that scenario, then I would say, well, look, if the university's not going to get involved, then this is an issue for local authorities, and also a good reminder for house corporations of why security measures are important, whether they be cameras or guards or those sorts of things.
Right. Excellent point. Okay. Well, I think that's my last scenario. Are there other variations that people want to talk about in the chat, or raise your hand or something? We've got some very expert people here today. Bob Furness, you've got your hand raised.
Yeah, I thought this has been very helpful. I thought you might want to expand the scenario 5 just to create the distinction between an off-campus fraternity and an annex, since annexes are kind of a real challenge on that matter. I don't know if that makes any difference,
Okay.
but a private apartment that serves in some way as an associated annex of
So
a
so so
recognized
Clark
fraternity.
Clark and Zach, assume that you have a campus, and on the edge of the campus you have a bunch of large single family houses that are rented out group by group to a group of students. And all the people who happen to have rented out this house all happen to be fraternity brothers, typically seniors as opposed to sophomores of the fraternity. So a lot of social events of the fraternity happen in this house instead of the main fraternity building, and so on. That's what Bob Furness meant as an annex. So, what in your view are the First Amendment rights of a fraternity to, quote, operate an annex? And I will put that in quotes because we have to figure out what that means. Zach, do you want to go first?
Yeah, and a fraternity's First Amendment right to operate an annex. I mean, they have the right to conduct their chapter activities, have the right to conduct expressive activities such as doing their rituals, going through their meetings, just like any other group out there, whether it's the chess club, the swim team, anything else. They have the right to express themselves. When it comes to the house, though, there are certain content neutral time, place, and manner restrictions the university can impose upon the groups. Um, for example, issues regarding fire safety, building codes, just general neutral policies that apply to all students like that. They can prevent the students from hosting, a large party that exceeds the maximum capacity of buildings. That'd be a fire code issue, for example. As long as it's applied to all students equally. So it really just depends on what the fraternity is doing, and as long as they're doing, their usual chapter operations and obeying university rules, and that should be totally fine.
Clark, do you have some insight into this?
Not much more to add there. I would just say that it's important when working with students on issues like this to remind them that no matter where you are, if you're in the official fraternity house, chapter house, or you're in an annex, you need to remember that the student code of conduct applies to you. So it's just important in how you talk about these things with students, because they can get the wrong idea really easily. But no, not much more to add. I think Zach did a great job.
I guess the other thing that one could do is one could almost imagine a safe harbor. If there are 5 or 10 things that you refrain from doing, would that protect you from being labeled an annex? Like, no fraternity property or furniture in the annex. The annex operates completely financially independent from the fraternity. Uh, the annex doesn't have any of the fraternity officers living in it. You could probably come up with a set of criteria to prove that you're just a bunch of guys living in a house as opposed to the annex of the fraternity. You don't fly the fraternity flag on your front porch. Uh, on the other hand, if you do have the president of the house living there, you do fly the fraternity flag on the front porch, and the fraternity treasurer handles your finances in the common pot of the fraternity. Then that would be indicia of being an annex versus just some random house in College Town. All right.
Certainly, that last point. Certainly, that last point would do you in. Another one that's going to be a little bit hard to get around is it only members of ABC fraternity who have lived in the same house. Is it is the house open? Is it actually on the open market, or has it only been rented by members of ABC fraternity or sorority for 40 years, or some other factors that often get considered in these analyses.
Right.
Yeah, the other one they tend to look to is social media to see if there's been activity and invitations coming from a
Great
fraternity
point.
email address, the communication around the party who's invited. So they're currently diving pretty deeply into this question whenever they want to try legitimately or illegitimately associate an apartment or annex with a fraternity.
There was an interesting Supreme Court case near my hometown, Stony Brook University, Belpaire on Long Island, and that there was a regulation saying that essentially individuals couldn't live together in a house unless they're like a family. So obviously there was 4 people in the house. I think there may have been a fraternity or not. 4 single guys living together in the university, and I believe the government actually said, no, you can't do this. This is not okay. This is against their rules, and they went to the Supreme Court, and the Supreme Court said that regulation was okay, that you could regulate, who lives in the dwellings, and it wasn't a right of intimate association. It was a very close, I believe, 5-4 decision in a divided court. And Scalia wrote this really scathing dissent about how the individual family is a nexus that should be free from state power and should be allowed to be out there in the world and not and protected by the First Amendment. So it's possible that if there was a regulation that did restrict who can live together in what house and what area, that would be struck down by what is now a new Supreme Court.
Okay. Doug Lamfer has a question.
Can I? Well,
Go ahead.
I think it's. I don't know if Doug has one or not, but I had my hand up for a little bit. I wanted to follow up on this.
Go ahead,
just a little
John.
bit. Thanks. Wanted to follow up just a little bit more. So if 3 or 4 people live together in a place off campus, and they're all members of the same fraternity, or most of them are, then is that anything that happens there considered to be something that happened at the fraternity, that the fraternity is responsible for? I mean, are there any limits to that, or is that just generally a true statement?
Well, I think there would certainly be limits to that. I think you started off by saying if it's all or most. So if 2 members are members of ABC fraternity, but the others are, 2 other roommates are XYZ fraternity, I think you're going to have a really hard time arguing that that's an official residence of one fraternity or another. If they're all a member of XYZ fraternity, and the fraternity, I mean, then you get back into those factors and sort of the facts. I think it was Bob who just said, about social media and events. I mean, if the annex, we'll try to avoid the word house, but if the annex is one where the fraternity repeatedly hosts fraternity events and lists that annex on, I know it's not invitations per se like non-students would think of, but maybe that's the address that gets posted on a social media announcement of a party or a tailgate, and it's where official fraternity events are happening. I do think that that toes closer to the line where it's an organizational facility, and then certain responsibilities would attach.
Okay, thank you.
And it's
Okay,
like before about, how do we assign group liability? How do we determine what is fraternity, and how do we punish the members, the group itself, for the conduct of individuals? So it really depends on, a lot of factors regarding the leadership, about what the students do with that. It's a difficult question. It's definitely a good question to ask.
okay, Doug, you have a question?
Yeah, this has to do with mostly private universities and colleges, which often will have policies that say if our student joins an unrecognized organization, he will be expelled. And so I wonder, and some will actually threaten that. So the student may be a student of this college, and he might join the church across the street, but the college doesn't care about that. The church is unrecognized by the school, but if he joins that fraternity that's unrecognized, he's going to be expelled. How can they, can they justify doing that?
So yeah, I mean, can they justify it? I mean, I bet you that it depends on who you ask. If you ask them, they're going to say yes. So it's common. Well, I don't want to exaggerate. I don't know that it's common, but there are certainly private institutions that say students can't be a member of an unrecognized fraternity, and we will discipline you if you do so. That in the general scenario, outside of a special state law, like the Leonard Law in California or the Massachusetts Civil Rights Act or something like that, you would generally not have a First Amendment cause of action because a private institution isn't a state actor. What you would want to do is say, first and foremost, has the university in doing that violated its own rules in some way? But in the scenario that they have a regulation that says we can expel you for that, student is going to be in a very bad spot to challenge that sort of regulation. And we've seen this exact scenario play out a couple times in the last couple of years. And what we are normally able to do is intervene, and this is when a whole community leaves university recognition. And we have had a private institution or two come back to us and say, okay, well, we're just going to amend the student code and say that if a student is a member of an unrecognized group, he's subject to discipline. We've been able to intervene and negotiate away, the university away from that position. And many universities have some sort of expression of support for the First Amendment somewhere in their policies, or so we would want to make sure that they're not. But it's important to remember that private institutions can change their own policies too, as they wish. They just have to follow the rules and how to change them. So a student would be in a really tricky spot there.
Yeah, we
Zach?
would argue that students
Okay.
have some right to
The one I
associate
picked up
with
on is there's a new one from Pat Block. She's in Charleston and for a wedding and
Okay.
stuff and driving back.
I'm going to mute you.
Basically, the bottom line is she's asking you to make sure.
Okay, Zach, you were saying, I'm sorry.
Oh, yeah, I was just saying that students have the same right to join off-campus groups. They have the right to join, the local Rotary Club or the bowling league or any sort of group that's outside the university's purview. Once a fraternity is unrecognized, once they're detached from once fraternity is unrecognized from the university, they stand on par with every other unrecognized off-campus group out there, whether it's in Ithaca or Cornell or anywhere else in the United States. Unless that group is, causing serious violence from a terrorist group, unless students are trying to join ISIS or something, the university doesn't really have any interest there in preventing students from joining these groups, especially if the interest that the student have is expressive. They're trying to join the army, for example. They're trying to join the local, Black Lives Matter association. If the university punishes them for that, and that's very clearly a violation of the students' free speech rights to associate with the groups they're choosing. Unfortunately, like Clark said, many of these universities do have restrictions on students associating with off-campus groups. We have a case that we advocated for previously, and we'll do so again at Potsdam University, student Potsdam, upstate New York. It's somewhat near Cornell, where they list all these different groups that are banned, that students cannot join these unrecognized fraternities. And we write to them, we say that look, what's your interest here? Why do you care? The students are adults. They want to join the groups they want to join. What is university's justification for punishing students for these groups? And I think the university is no longer punishing students for doing so, which is good. The policy is still in the books, and we advocate for the university to rescind this policy and for all universities to respect students' right to join off-campus groups like unregistered fraternities.
Okay, but can't we make a distinction where, on the one hand, if a fraternity is adjudicated of a violation and is suspended for X years or expelled permanently, then the recruiting and joining of new people into that group could presumably be against the code. Whereas in the case posited by Clark, where the entire IFC just all derecognizes and they haven't been convicted of anything, but they just all say, we don't find our relationship, business relationship with the university warrants us continuing recognition. We're going to go a separate way. And they haven't been convicted of anything. Isn't there an important distinction there?
I mean, I would argue, and I could be wrong, I'm open to being, wrong and countered here, that the university's jurisdiction is contingent upon the relationship between the group and the university. The university gives the group campus resources, space to do its events, money, recognition. It can control the relationship between the two entities. But once the group is gone, they're hands off, they're no longer part of the university system, then the university has no power to tell them what to do. But the power to tell them what to do is they can tell them the local Applebee's in town. They're simply not affiliated with the university anymore. So I don't think the university, I think the university can discourage students from joining groups that are disfavored. The university can say, don't join these groups. We don't think they're good, but I don't think they can prohibit students from exercising their own right to associate with the groups.
Well, that brings up another very interesting question, which is that there have been questions, like, for example, at Harvard, when the two of you came to talk to us last time, about to the extent to which a fraternity can discriminate based on gender or sex. And Title IX has a specific statutory exemption for the sort of terms and conditions of membership being exempt from Title IX. So the Title IX law says you can't discriminate based upon sex, except fraternities and sororities, their membership practices is the phrase. Membership practices are exempt. So where do you guys stand on all of that? That is to say, even though there's a statutory exemption, could a university order its fraternities to be co-ed? Clark?
Well, I think practically speaking, after the Harvard litigation and after the Supreme Court's Bostock case, I think that's probably pretty unlikely. I don't think most universities are going to want to get into multi-million-dollar litigation with fraternities and sororities over this question. I mean, if we can beat Harvard, I don't know that many others are going to give it a whirl, but certainly our community would be ready and willing to fight back. I do think it's important. So you're right. Title IX exempts the membership practices of social fraternities and sororities. I do think that it's really, I always say this when this comes up because I think it's wickedly confusing. That does not confer a right on fraternities. That is an exemption that applies to universities to allow universities to recognize those groups. It does not provide fraternities or sororities with a private cause of action to say that this, or private right of action, that this exemption is being violated. Title IX, that exemption flows to universities, not to organizations. I mean, it's great language, and certainly we work with schools all the time how to tailor non-discrimination policies to be thoughtful of that exemption. And most are willing, well, universally, they're willing to listen to our input. But I just think that, the associational issue of single sex hasn't been clearly litigated by the Supreme Court, and the times that have not been particularly favorable to fraternities. So, and then a lot of people say, oh, well, we have the Title IX exemption. And I'm always very careful to say, we don't have the Title IX exemption. That applies to universities, doesn't give any rights to fraternities on their own.
Okay. Zach, do you have anything on that?
No, I agree completely with Clark. It's a really, really good nuanced point about Title IX, the exemptions and how it operates. It's definitely a tricky, legal system to navigate, and it's great that, we can go and get in front of students and administrators and kind of educate them about what this means and what their rights are. So, yeah, it's not something I think we want to litigate again or really get into. It was a great decision against Harvard, and of course, Bob Huxley was also a good decision. So I'm glad we have that. But if we do see fraternities like that, fraternities like Harvard that do try to institute a blacklist or try to force these groups to go co-ed again, we definitely want to get involved with that. We would push back against that, this insistence to be co-ed and have this all-comers policy, because there is a First Amendment right to associate and to not associate. And groups have the right to determine their own membership, as long as it's not discriminating based on race or other protected categories.
Okay. We have time for one more question. Does anyone want to ask the final question? I guess not. Well,
Bob, I have a quick
sure.
end of meeting question. So,
Okay, Mike.
do the Title IX people have an event where your perspective would be welcome? National conventions, things like that. It just feels like there's one side talking one way and one side administering another way. And, you provide cogent perspectives that I'm curious if there's opportunities at that level.
Quick answer, the main industry conference for Title IX administrators that I'm aware of is the Association of Student Conduct Administrators. There's undoubtedly others at this point. I've been to that a few times, and you're right. I mean, it's a lot of like-minded folks, but not universally true. But that's the main sort of industry gathering that I'm aware of for Title IX administrators. Zach, do you know of others?
Yeah, that's the big one. There's also an association, I think, University General Councils, with some weird acronym that I can't remember right now. They're all like very long acronyms. But yeah, they're always very educational. They're really people just there to learn, to fulfill their their continuing education requirement, and to get up there in the state of the law. So we try to get in front of these organizations to speak to them if they want to hear what we have to say. And it's always great talking to administrators. It's always a pleasure.
Okay. Nick, do you want to tell people when our next AIFC meeting is, just to be helpful? Is it December 8th? Or John? I think it's December 8th. So watch for the email on that. We want to thank our two guests, Clark Brown and Zach Greenberg, for sharing their time with us. Everyone, I think, has found this to be very valuable. And
thank you very much. And yeah, the meeting is scheduled for the 8th at 6 p.m. 6 p.m. Central. I'll send a note out.
Right. And
thank you for having us. And we'll do it again in a year or so.
Yeah, thanks for having me.
Hopefully it'll be better news.
Yeah, should be a lot more happening in the year. But great seeing you, Clark. Thanks for having me, Bob, and have a good night, everybody. Appreciate it.
Yeah, Clark said that Nick beat Harvard. Unfortunately, the Cornell football team hasn't done that for years. But
okay,
yeah, well,
we're never gonna let him forget that one. So
okay, thank you.
I got to bring it up anytime I have a chance.
Okay, so we'll adjourn the meeting. Thank you once again.
Thank you all.
Yes, thank you.
Bye.
Take care.